Good evening and welcome to this conversation. I'm Faye D'Souza. We bring you a conversation every time something really important that affects a lot of us happens. And secondly, whenever we find the perfect guests. So today is one of those days where we found the perfect guest to comment on something really important that has taken place. Now, the Tejpal case that many of us will remember back from 2013, we finally had a verdict now. We must note that it's taken 8 years. That by itself is something to worry about. The state government of Goa has called this verdict erroneous in law and unsustainable. And the Solicitor General of India, Tushar Mehta, arguing before the Goa High Court, has said that we owe it to our girls that we hear the appeal on this immediately. It's rare, but once in a while, I do agree with what Mr. Mehta says. This is one of those cases. But why does he say we owe it to our girls? Now, this is an order that I, unfortunately, because of the hazardous conditions of my job, had to read today. It runs into more than 250 pages, and it is terrible for women to even consider what is written on it. It basically talks about immoral character. It talks about loose character of women. It examines whether prior sexual behavior in any way has any sort of bearing on a case. It actually says at one point, even a woman of loose character has the right to refuse sex. It suggests that this particular individual, and I must note the worst part about it is that it names her, which the law does not allow anyone to do, but here we had a court that did it. It suggests that because she is a journalist who regularly wrote on rape laws, and she had a keen understanding of rape laws, it put her in a position to actually structure her accusation in the most intelligent way. And that in some way worked against her. The fact that she didn't file her complaint immediately, the fact that she contacted lawyers and members of the Women Commission before filing her complaint in some way to strengthen her complaint is seen to work against her. Her communications with lawyers is actually printed, which is something that personally really worried me. A lot of the case deals with poking holes in the victim's testament, in her, in basically, it felt like it was the victim who was on trial and not the accused. It also said that the experts in question, her friends who are also journalists, the lawyers she had contacted, helped her doctor events and add incidents. It also said that because she claimed that she was shaken from the trauma and she was blinking back tears when she left the lift, it said CCTV does not support the fact that she was going through shock or trauma or that she was blinking back the tears. It effectively has listed out ideal behavior for a rape victim or a victim of sexual assault, of how you should look traumatized and you should not go back to work and you should not look normal in photographs, and you should be visibly traumatized for everybody to see. And if you don't do that, according to this particular court, at least you don't qualify as a victim. Now, women across the country have been shocked and ironically traumatized by this order, which is why the Solicitor General is arguing that it be looked at immediately, other than the fact that there's a very pressing and serious problem here in the fact that the order has named the young woman here, which is against the law. How do we understand in our public conscience what this order means? Does it change the way rape cases will be looked at in the future? Does it mean, I mean, for me, at least as a journalist, it effectively read that if something ever happened to you, that you should never report it, because no good will come of reporting. And I want to also note how much this one woman has been put through in the last 8 years. And here we have, at the end of the day, a judgment that completely, knocks everything on its side. So we're going to attempt to understand this judgment today. Joining me this evening, Karuna Nandi, advocate at the Supreme Court, and Brinda Adige, who is an activist who has worked on so many cases with so many survivors and victims of sexual abuse that she becomes a really strong voice to bring in at this point. Ladies, thank you so much for making time to speak with me this evening. Ms. Nandi, if I may please bring my first question to you. Other than the fact that the name of the victim has appeared in this judgment, which is against the law very clearly, this whole idea of behavior and visible trauma and no any sort of appearance of normalcy leading to a questioning of guilt. Is this how rape cases are supposed to function in court?
Explicitly not, actually. The Aparna Bhatt judgment of the Supreme Court lays out quite clearly their directions to trial judges and the manner in which they must conduct these sorts of trials. And this court, unfortunately, has gone directly against those directions. This was a decision that was made on the 18th of March of this year. And they say, for example, that courts should desist from expressing any stereotype opinion in words spoken during proceedings or in the course of a judicial order, to the effect that good women are sexually chaste, for example, right? Also, testimonial evidence provided by women who are sexually active may be suspected when assessing consent in sexual offense cases. So they say that when you are sexually active, it's not relevant to your consent. They also say that lack of evidence of physical harm in sexual offenses cannot lead to the inference of consent by the woman. The law is extremely clear on that. So the fact that all of this has in not 250 pages, but 527 pages and about 400 pages of examining the prosecutrix and her text messages and who wanted to sleep with her, allegedly. The court thinks that PW 56, says the court, wanted to, I'm not going to take the name of the person, obviously, but PW 56, says the court, wanted to have a sexual relationship with the victim, which is why their testimony is compromised.
Yes.
She says that she was in the habit of having these flirtatious conversations, completely forgetting that consent is the key to whether the law steps in or not. So does this court know what this court is supposed to be doing? This court is not, having a chat with a sort of friend about the morality of the prosecutrix. This court is making legal decisions, ostensibly in accordance with Supreme Court decisions, ostensibly in accordance with the Constitution, ostensibly in accordance with the proviso to Section 375 of the IPC, which says that consent must be willing, it must be explicit, and that it doesn't matter whether you have medical evidence or not.
Ms. Nandi, I found it interesting here, and you're right about the fact that the entire case seems like the victim or the prosecutrix, as they call her, is on trial because her phone records have been looked at, her text messages have been reproduced, her relationship with every single witness has been, examined. But it also starts off with justifying that, saying that because under India's rape laws, the statement of the survivor/victim is enough to convict someone, we have to really, really examine that statement for inaccuracies, which I understand to be logical. But the two, even so, they seemed a bit extreme. Could you explain to us how this ought to function in court?
The way it should function is that you can look to assess the robustness of the witness's testimony. Are there any material contradictions, allowing for the passage of time, allowing for the fact that it is after 8 years that the examination, whenever the examination happened, because the verdict is after 8 years, but whenever the examination happened, the lapse of time between the 164 statement, between the letters that were written immediately after the event, and between the examination of the prosecutrix, right? So you have to allow for the lapse of time. So you can't look at whether the prosecutrix picked up the panties or pulled up the panties, right? Secondly, there's a gross negligence, in my view, in the way that the corroborative evidence has been dealt with. Because if you look at the email, and there is quite a lot of corroborative evidence.
Yes.
Right? Much is made of the first person that she spoke to after the incident. What the judge fails to take into equal account, or close to equal account, is the fact that she spoke to a large number of people after. And that, not that it's relevant, but that she was extremely upset about that, the incident, and by all these accounts. Thirdly, in terms of corroboration also, the fact that there is a letter saying that sexual advances were made that were non-consensual, that she was not willing to participate in and accept, at the very least, okay, we may not know what the content of those sexual advances are, right? We may not know that, it may not be clear just from that letter whether that includes digital rape. But at the very least, it would include words. At the very least, it would include words or gestures. And this is where one of the biggest failures of this judgment occurs. The judge failed to add section 509 in the charge. And that can be added actually at any stage, regardless of when this judge came in, because as long as the material ingredients of the charge have been put to the accused and have been answered by the accused, there's a Supreme Court judgment by Justice Chandrachud saying that the section can be added at any time. Section 354A includes sexually colored remarks that are short of criminal force, that are short of physical action. And so therefore, why was this man not convicted for that? In very briefly, the judge seems to elide over the fact that this man was in a position of power. She herself, and this is the only point at which she finds in the favor of the prosecution and the victim, that he was in a dominant position, that he was in a position of power. So if he was in a dominant position of power, when somebody who is the age of your daughter, and in fact best friends with your daughter, comes to you and in a workplace context and makes a complaint and says that you sexually harassed me, that is coercion. How is that suddenly something that how is the power relationship suddenly flipped there? So that is dealt with in a very brief way, eliding over it. Whereas, in my view, this court, at the very least, could have convicted for section 354A, which is sexually colored remarks that are unwelcome.
And I will come back to more details of this case, Ms. Nandi, because there's also a lot to be said about the IO, the investigating officer here. Apparently, according to this judgment, failed to actually collect and preserve any evidence at all. That would have helped the victim or the survivor in this case. But I want to bring in my other guest, Ms. Adige. Good evening. Thank you for joining us. I'm assuming that this was not new or surprising for you. This is a case in the public eye. But on a daily basis, you deal with how the system treats women and children who are targets and victims of sexual assault and abuse and rape. Is our system fundamentally flawed here? Because we talk about sensitization of cops and of judges and of prosecutors. Is that making any difference?
If there is any difference that is being made with all of these sensitization programs and training, I think it's just a drop. Of course, somebody profoundly might say that the drop makes the ocean, but this is not taking us anywhere. And yes, to the first question that you asked, Ms. Faye, the system, the structures are completely flawed. I also want to say that we cannot just talk in an abstract fashion as the structure and as the system. We must address the issue of the functionaries who hold the power within these structures and systems to dispense their duties, and they don't do it. And they are never pulled up. They are never held accountable. They are never challenged. They are never questioned. And that becomes so difficult because I was also hearing Miss Nandi speaking, saying the courts, why not the judge? Why not the prosecutor? The functionary over there, we never hold that functionary responsible. There is a system in the courts to review their cases, to review the judgments, the verdicts that are given by the judges. What happens to those judges because their verdicts are not in line with the law? Nothing. They continue to get their promotions. Of course, their salaries are guaranteed at the end of every month. Their perks are not reduced. They have nothing to lose. Every day we see the women who are struggling to register a case at the police station, after they register the case, going to the courts, finding it so difficult to find lawyers. With due respect to Ms. Nandi.
No, absolutely.
Very often the people that I work with are from very vulnerable, poor communities, impoverished communities. And so paying for a lawyer is very, very difficult for them. Now let's look at the state giving that kind of support. Who are the lawyers whom we get from the state legal service authorities? Somebody who's passed out 6 months ago, somebody who's not very interested or keen to take up these cases, but must take it up for the sake of experience. And yes, they also charge. So when we talk of the systems and we talk of the structures, which according to me are absolutely patriarchal, we also need to address this to say, who is to set it right? So we keep asking abstract questions. Who'll set it right? Where do we want to start from? Where do you want to start from? Because this is a circle. I don't even know where one can start from. But if you ask me, I want to hold that functionary in that particular court, in that particular police station, that particular prosecutors and prosecution office responsible, accountable. He or she must know that they have to be answerable for every case, but they never are. So we continue, and we are now 75 years down the line with nothing changing.
In fact, Ms. Nandi, what our politicians do on a regular basis is whenever there is a case that is upsetting people, they call for a death penalty. Let's introduce the death penalty, feeling like that is going to solve all of the problems. But effectively, if we look at this case, what the judge has told us is that in order to be an ideal rape victim, you have to be sexually inactive, which means you have to be a virgin. You have to have never made a sexually explicit joke on WhatsApp with any of your friends with regards to anything. You never have to have, gone out with your friends, had alcohol, had any sort of sexual experiences. You shouldn't, after you have been assaulted, go back to work and finish the job you have been assigned, because that is a sign that you're not really traumatized. You should remember the sequence of events very, very clearly so that you don't change any of the details later. It's almost as if the judge is telling us that if you don't fall in any of these categories, there's no point even reporting because nobody's going to believe you.
To that, I will add that if you are the ideal rape victim, you don't get legal advice. You're not supposed to talk, even if you're speaking to the National Commission for Women, even if you're speaking to a former additional Solicitor General of this country, Indira Jaisingh. No, don't do that. That's a constitutional right. If you're an ideal rape victim, according to this court, you cannot also know too much. Because if you know too much, the onus on you to go and get an immediate MLC, to not bathe, to go and get a medical legal report, to go and then file a FIR immediately, having wept publicly and demonstrated presumably the appropriate shame, is something that you have to do. Mm-hmm. So here, on the one hand, you can't get the legal advice. On the other hand, you have to remember everything perfectly accurately, right? Plus, let us be clear that women who complain are not looked at very kindly. So the Adarsh victim, the ideal victim, is actually a contradiction in terms. She doesn't exist, you see? And let's be clear that she's also said that you have to give up your constitutional rights to be an ideal victim here. The thing is that I'm going to address Brinda Adige's point because I think it's a very important one, which is that, and this is something that we have, many of us have been saying for years, and I'm very invested in this idea of accountability. When we took out the manifesto, which looked at the sort of large-scale reform of basically according to, I think that if those 6 points were implemented, then it would have led to the destruction of patriarchy, actually. I know it's a big claim, but I do believe it to a significant degree. Now, I think that when you recruit a prosecutor, or when you recruit a judge, or when you recruit a police person, it can't just be an exam on the law. You have to examine whether they're going to perpetuate the might is right result that exists in society, and are they going to make it worse because of the power that they wield, right? Instead of redressing it and sticking to constitutional and other law, are they going to make it worse? So in the interview, you've got to test for that. What is your attitude to gender rights? What is your attitude to people of different religions? How do you make decisions when you have somebody who's very poor in front of you? How do you make decisions if you have a Dalit person and you are, 9 times out of 10, you're going to be Savarna, right? How do you think about these issues? And that's when you get recruited. But in addition, when you are promoted or when you are penalized, these are issues that must be examined. Now, there was an example where there was a judge, I think in Bombay, that had made egregious decisions on POCSO and placed a large number of children at risk. And I think she was suspended. But I think on a regular basis, and I speak as someone who has conducted 2 trainings at the National Judicial Academy, 2 workshops with judges, one of them on gender justice. I think it's vital to suspend people, send them to retraining, not just for the message to be sent out, but to make sure that somebody who has suffered this sort of huge violation of privacy, somebody who has suffered doxing because their name has been put out in violation of Section 228A of the IPC. You're not allowed to disclose the name of a rape victim. You're not allowed to disclose their partner's name in a way that sort of reveals who they are. Then I think the Superior Court should actually give damages to the victim and there should be corrective action. And I think all of these steps, and if should all be looked at systemically, including legal aid, including the other issues, and there needs to be a finance bill that is then passed to fund all of it from a systemic perspective. It's not rocket science.
So what Ms. Adige is suggesting, even, and this is obviously a sensitive topic, even to do with judges, do you believe that they should be sent for retraining? Who makes that decision?
The high courts have administrative decision-making over trial judges. So it's the high court that would make such decisions.
Okay. And one of the questions that have come, and this is a little, it's a contentious question, but I'm going to ask it because it comes up every time, is that there are so many fake cases, so many false accusations are made to ruin the reputation of wonderful men in powerful positions.
Yes.
Hence, shouldn't these things be examined with a fine-tooth comb, piece by piece? Isn't that fair, given what is at stake for the man in question?
Absolutely. Of course, it should be examined with a fine-tooth comb. If you see, the thing is that there's a huge burden on the evidence of the prosecutrix. So it has to be examined by a fine-tooth comb. But what are you explicitly not allowed to do? You're explicitly not allowed to bring in her previous sexual history. You're not allowed to do that. Whether a fine-tooth comb or a large tooth comb or a JCB, you're not allowed to do that. Right? You're not allowed to place a burden on her that doesn't exist in law. You're not allowed to make up the law as you go along.
Yeah.
You're not allowed to vilify her. You're allowed to see what you are allowed to do and what you must do as a judge. Because you must look at whether her testimony has material contradictions that cannot be explained by the passage of time or by a reasonable change in recollection, and how relevant they are to the case. That's one thing you can do, must do. And the second thing you must do is to deal with any corroborative evidence and give it the weight that it deserves. And frankly, I think there's one thing that we must remember. We must remember that 2 days prior to the judgment being passed, Tarun Tejpal wrote a thank you letter to the court, to the justice system, to a large number of people, anticipating his victory. He wrote this on the 19th. He changed the date later. Were there 2 such statements? Did the other statement speak of defeat and hope that he would win at the High Court level? We don't know because he hasn't published it. That's something important, I think, to demonstrate bona fides.
I also want to ask Ms. Adige the same question, because so many people ask us this. Some couple of people on our chat window have asked us this as well. False cases and the examination of false cases and the idea of fairness to the accused. Isn't it important that the victim's statement be treated with a certain level of I don't know if suspicion is the right word, but that's effectively what this case has done. But in our law, the victim statement is enough. It has to be considered. Enough. So where is the balance there, Mr. Adige?
See, absolutely, I agree that you have to examine the statement of the victim survivor and the witness. Yes, do examine it. The procedures are well laid. There is no cause for you to say that this is what the law says. The law also says how you need to examine it. But what is happening today, the experience that we have is the police examining that. And that is not the job of the police. The police's job is to file the case. The IO's job is to put in the statements and get all the evidence that he or she can and present it to court. But what is happening today? You look at the cases that we take to the police station. Let it be rape, let it be domestic violence, any form of gender-based violence that we're talking about, and the woman goes, the woman is looked at, the statement is taken on a premise of doubt, on a premise that she is coming there only to, with malified intentions. Never that there is a complainant over here. So that's the first flaw. The job of the police, they are not doing that enforcement of law. From there, we need to go to the prosecution and everything. By the time it reaches the court, it's over 2 to 4 years. Now that is a problem by itself, because by now, this victim survivor has already been threatened, may have lost out on medical grounds, on her job, her family, her friends, her entire support system. What will the court or the so-called system do or does for it? Nothing. The court also said at one point some years ago that there should be a committee that will look into dowry harassment cases before the police files the case. So you're saying that you yourself doubt your police doing a good job of whatever the law has been laid down for. What are you talking about?
But
You're
that
not
was
clear.
fixed. They did get rid of that subsequently. It's a completely wrong judgment.
Absolutely wrong. Of course, 2018, the Supreme Court threw away that judgment. But the question here is, are you making a law and having that system and its mechanisms to address an aggrieved person, a person who has been violated? Or are you sitting here on a high horse of patriarchy and saying, we doubt you? You have every right to doubt everybody, but it has to go through due process. And then you place on the table A, B, C, D, and that is why this case cannot go any further. You can't do this at the first instance. And let's not forget everybody else around her. There are lawyers, there are friends, there are family, and a lot of other people who support or do not support her, and hence say, this is what I want to do. And let's also place on record, these laws that have come because women have documented thousands of cases, taken it to court and said, now we want a law for this. Because you have less than 10% of those thousands of cases, you decide that these are false charges, false cases, want to take revenge. I think that is wrong, one. Two, we also need to ask ourselves this question, is training enough? Attitudinal change takes years. To remove this attitude from me is going to take years. Once you put me through a reorientation or a training, how do you evaluate that I am fit for that position? There is no psychological evaluation done. It is important. We need to do it. Why don't we do it? Why is it that because I sit on this chair, I'm above everybody else? I come here with a neutral frame of mind. That is what most judges say. Really? If you were coming there with a neutral frame of mind, you would have made even statements that are neutral, where we will not fight with you on making these kind of misogynist, sexist statements. But that is not true. You don't come with a neutral frame.
Ms. Adigini, I have to ask you this question, which Ms. Nandi also pointed out. In this case, as has been pointed out by the court, the person making the accusation, the victim in this case, had access. She had, she had friends in high places. According to the judgment, her stepmother knew Ms. Indira Jaising. All of her friends were journalists. She had the ability to understand the law. There are thousands and thousands of women in our country who don't have that ability, who don't have fancy friends, who are invariably members of the Dalit community, who then have to fight this system. How much worse is it for them?
You're absolutely right. It is worse for all of these people who have no access to education, literacy, Android phone, download this app and you call the police and they'll be there in 10 seconds. All of this, everybody has a problem. And here the other question that you asked, she had people in high places, and why did she not complain immediately? Please understand what women have gone through, are going through for centuries. Silence is valued. That is why you are a good woman. Now, how many of us want to be called as a bad woman? I don't know. How many of us don't want to go to heaven? The society keeps telling me that good women go to heaven. So all of us want to go to heaven. Making life miserable for me, hell for me over here. So when people ask questions, you had people in high places, why did you not talk? She has to come to terms with all this because she herself may be asking these questions. Why was I not able to stop it? Why did I not run away? Why did I? She herself.
Ms. Adi, I'll come back to you. I understand that Ms. Nandi needs to leave. But quite frankly, for me, heaven with only good people sounds slightly dull. But let me bring in Karuna Nandi on the court seems to suggest that if you don't have access to powerful friends, that it will take you more seriously. But that's not the case either, is it?
No, it's not the case. Yeah. Bhavri Devi still hasn't had justice. Bhavri Devi, who brought justice for women, more privileged women in the formal sector, right? Because the local area committees haven't been set up, and those are the ones that are to be accessed by people who don't work in, say, companies, right? and other formal workplaces. Bhavri Devi hasn't received justice. So let's be clear that it's a double bind. Privileged women have also got patriarchy set up against them. Here you have the words intelligent and intellectual sort of thrown around a bit like insults. The fact that she had access, access to, that she was able to complain to the HCW, the fact that she had access to lawyers is taken as a negative, right? So the point, I think, also is that patriarchy is actually a double bind. South Delhi, for instance, was one of the areas that has the highest female feticide rate some years ago. The labor workforce participation rate in Delhi is 11%. The national rate for workforce participation for women is 25%. Delhi is significantly below that. So I'm not saying that Dalit women have it much worse, right? If you're a Dalit woman, if you are Soni Sori, if you're an Adivasi woman, the kind of brutality that you might experience will very frequently be much worse. But patriarchy is deeply imbued and in all levels of society and affects privileged women in very, very strong and damaging ways as well.
Ms. Nandi, I know that you have to leave, so I want to thank you for your time.
Thank you so much for joining us.
Thank you. Ms. Adike, if I bring this question back to you right now, and I also want to ask you a slightly personal question. As women, we live with the idea of the possibility of being harassed, molested, assaulted constantly. Right? I think the only time we've, at least I've not worried about it is the last 1 odd year where I've been in lockdown at home, but I have to acknowledge so many other women who experience domestic violence and marital rape who have been in lockdown with their abuser. For them, it's much, much scarier. But having to read about a case like this just makes us feel so much more unsafe. And I want to understand how you felt when you read about this judgment and how you processed what this judgment said to us as women.
At the outset, I was outraged. I was angry and then frustrated. If somebody like her, who has been able to make a complaint, formulate her statement, go all the way up to Women's Commission, this is the kind of verdict that she gets. Every day we are struggling with women. Like you mentioned, many of them are afraid to go and speak to the police station or go to court and make a deposition because they're afraid of how they will be looked at when they come back home. By their families, by their neighbors, even at their workplaces. None of this makes it easy for them. None of them, we may say that, we must be sensitive, we must understand. Nothing happens to give her that courage, that strength to continue with these cases. And all of them, nearly 85 to 90% don't even reach that logical conclusion. Those cases don't reach the logical conclusion. If this is the situation of a person who had so-called access to a phone, to somebody to complain to be able to consult and discuss the case, and this is the situation, one can imagine what is happening with the women that we are working with, who have no access, who change lawyers don't turn up. Every time you get lawyers, many times the lawyers that are given to us also free of cost or at concessional charges are men, and their thought processes are the same. So you have to convince this person who's going to actually argue and debate on your behalf for you to get the so-called justice. And it isn't easy. It's frustration, but for me, I personally have geared myself to be angry because it really absolutely propels me to continuously keep going forward and say that nothing's going to keep me back or bog me down with anything of this. And I also continue to do this with the women. It isn't easy because you understand when someone comes and tells you that I'm afraid to go back home today because my husband is going to do all of this and there's no way I can complain. And if I do call, It's just that I can hear, there are women who call me up at 12:30, 1 o'clock, 2 p.m., 2 a.m. in the morning and say, you just keep talking to me because I'm saying that you are in trouble and so I need to talk to you. Say, okay, fine, you keep talking to me. There's nowhere you can go to. Because of the lockdown, there are no shelters that will take you in. If there are any shelters, then they want to take you in only after you show them a COVID negative certificate. At 1 a.m. in the morning, there's no way I can show you a COVID negative. If I do have a COVID negative, then it should have been in the last 48 hours because of the kind this pandemic and the virus is. All of this is systemic. All of this is a structural problem. We do not have, a couple of days ago, a couple of weeks ago, there was this discussion that we were having with the government on how to handle this at the ward level. And I'm talking about shelters that are required for women. And somebody says, let's discuss the COVID issue first. This is the COVID issue that we are talking about. If there was no lockdown, maybe this woman would have been able to go to a relative's house or a friend's house, which is not possible just now. So when we are talking of the pandemic, we want to talk about all of this together and have the government understand that women are going through violence of a different nature at a higher level, deeper intensity, and the system is not addressing these issues because somewhere along the lines, they think that women must remain silent. Worry about it. You're not dying just now of COVID, so don't worry about it. We'll talk about it after the lockdown. Yeah. I may not be alive after the lockdown. I'm gone.
Very well put, Ms. Vrinda Adige. Thank you so much for joining us. A lot of our audience members have also appreciated the number of medals hanging in the background of your frame, apparently. These are Ms. Adige's kids who are high achievers. So we wish them very, very good luck. Thank you for joining us. And hopefully we will see some sort of cognizance taken of the case in Goa. We have to also push for other cases that are not in the public eye, that don't get this much media, where women suffer far worse as well. At the end of the day, it is about delivering justice, and justice is not going to get delivered in this fashion. Thank you for watching. Good night.